Were late fees subtracted out for the payments made into court escrow?
She was late every time it was paid.
Why can't I just get an answer to my question? They would send you the bill anyway. You could always go online. You can look it up.
I just was concerned. That's all, sir.
But why was it important for you to change the name?
I thought I needed to be responsible for it. That's all. I just wanted to make sure I got it.
You're the homeowner.
Let's see, 8136 19,800. Yeah, that's what.
Yeah, that's what I get for the 6
You don't have to
months.
point that out to me. I understand that. Okay. 19,800. That's correct for 6 months.
Okay, so what's our difference? When you gave me the 22, now 399, you gave me 22, basically 499. And then, but when I count the 6 months, I get 19,800. So I don't.
Okay. Well, we also get 19,800 for 6 months, but we add to it the water bill of 1950 and 80.
Gotcha. Okay.
And we get the court costs of 183.59, and we get late fees of $900.
Late fees are where many landlord cases unravel, not because late fees are illegal, but because they're often misapplied. Judge Simpson immediately starts questioning whether late fees can be charged when rent is paid into court escrow. This is critical. Escrow payments are court-controlled. Landlords do not get to punish tenants for complying with a court mechanism. The judge's tone here suggests skepticism that these fees are valid at all. Late fees exist to incentivize timely payment to landlords, not to penalize tenants navigating judicial processes. When landlords blur that distinction, courts step in.
Late fees of 900.
Yes, they're 150 per month.
Were late fees subtracted out for the payments made into court escrow?
She was late every time it was paid.
Why can't I just get an answer to my question?
No, they were not taken into account in the money she paid to the escrow. She paid $3,300 twice.
So I want to be clear on this, Ms. Anderson, because Ms. Lyman is claiming, and throughout the course of this case, and counsel, you haven't been here while it's been going on. She's claiming interference with her possessory right.
No, sir.
This is where earlier threads converge. The interference claim isn't abstract anymore. It's contextualized by everything that's happened. Alleged surveillance, water bill control, repeated appearances at the property. Judge Simpson is careful here. He doesn't accuse outright, but he acknowledges the claim has been consistent throughout proceedings. Consistency matters. Courts are more persuaded by repeated, corroborated allegations than by sudden claims raised at the end. This also explains why the judge keeps referencing earlier hearings. He's evaluating behavior over time, not isolated incidents. Audience engagement. Do you think patterns should weigh more heavily than single events in cases like this?
On the day that Ms. Lyman is claiming, before I go back and look at this tape, did you send a gentleman to the premises? Make sure you give me a correct answer.
That was your question? Okay.
Did I send a gentleman to the house? No. She said I was in the car.
You have also, to this court, indicated you were not in the car in front of the house. Is that correct?
Sitting in the car in front of the house? No, I drove by one time. Just to check on the house. I've driven by one time in 4 months. 4 months I've driven by one time.
He's not asking about that.
No, I was not in front of the house waiting for anything.
Do you know anything about the gentleman that came to the house and came around the back of the premises as Ms. Lyman has indicated.
No,
Ms. Lyman, just to be clear, what date was that? November 10th.
At like 9 in the morning.
Specific dates add weight. November 10th at 9 a.m. is not a vague memory. It's a time-stamped allegation. Judge Simpson requests clarity because specificity allows verification. What's notable is how the landlord denies knowledge while the tenant remains firm. This creates a credibility fork in the road. Someone is mistaken or someone is minimizing involvement. Judges often resolve this by asking who had the motive and who had control. This moment reinforces why video evidence becomes central later. In modern landlord-tenant disputes, cameras often speak louder than testimony. Viewer question: when testimony conflicts but video exists, whose story should the court trust more?
She has not.
She's asking. It was like the same outfit like on today. It was like a tannish, little pinkish color that you
Tannish.
like the hijab.
Okay. Give her Ann's email and have her send it.
So it wasn't the first time that somebody had walked around the house. She sent, I believe, her contractor before it all.
a lot of Muslim women in the neighborhood, a lot of women wear hijabs in our neighborhood.
And what's your argument in terms of the interference with her possessory interest?
There's been no facts presented other than this person who walked to the back of their house about interference with her possessory interests.
Okay, so that, and I hear you, counsel, but can I just say that? And again, you weren't here when that other case, and when I was coming back to you by decision, actually, she's put forth other claims of where your client has gone to the house. This one that she put forth today is one that wasn't included in that.
Well, I know that you were not again. What the heck? I'm sorry.
The only time I was at the house was when he was court ordered. I haven't been at the house since. I don't go to the house.
Oh, okay, all right. There was a court. I know that there was a court-ordered inspection of the
Yes,
house, and she was.
because there had been problems with coming to the premises and then claims that she wasn't able to get in.
Right. You were here. You were there at the inspection, right?
Yes.
Okay. She was there at the inspection.
Correct.
Me and I.
Okay.
I haven't been specs
You've not been there other than.
other than driving by.
Oh, you already talked about driving by.
Yeah, just to make sure the house is still there.
You've not been on the premises
No,
except for
Have
that
you
inspection.
sent others on the premises?
no.
You've not authorized anybody to be on the premises, Ms. Anderson?
No, I don't even know if it's still there. I drive by every now and again, to make sure it's still there. But I don't.
Okay, you already said that. Okay.
I'm gonna say, counsel, that, and again, you're at a slight disadvantage that doesn't quite fit with what's been presented to the court previously.
Judge Simpson signals a credibility problem. When current testimony doesn't align with prior claims, courts take notice. Consistency across hearings matters as much as consistency within one. This doesn't mean someone is lying, but it does mean the court will scrutinize explanations more closely. Judges remember patterns. They compare narratives. And when stories shift, trust erodes. This is especially damaging in cases involving alleged harassment. Those claims rise or fall on reliability. Audience question: should courts give parties leeway to clarify over time or expect absolute consistency?
So, all right, you sent that video.
Yes, I said.
All right, so Ann has it.
She said she'll let us know when she receives it.
All right, so what I'm going to do is I'm going to stand in recess, and counsel, I think we have your email.
I don't think so.
No, we don't.
I'll give this lady.
So
Yeah.
why don't you give it to her? And then what I'll do is I'm going to take a recess. When it comes through to us, we will send it right to you, counsel.
I'd appreciate that.
Because that way I know it will go to your phone because you've been answering it all. No, I'm just kidding. Yeah, all right.
Spam calls that are spam.
No, it's okay. I understand. Our court's going to stand in recess. Everybody can be paid.
Somebody. Thank you.
The court has had an opportunity to review the videos and submitted by the defendant. Is there anything that plaintiff wants to say regarding those videos?
We know nothing about the person being there. We don't recognize the person or the car.
Denial without explanation is risky. When the landlord says she doesn't recognize the person or car, the judge listens, but he doesn't stop there. Recognition isn't the only issue. Authorization is. Courts understand that landlords can distance themselves verbally. What matters is whether the conduct connects back to them. Patterns, timing, and context all factor in. This moment keeps the interference claim alive rather than resolved. Viewer question: is lack of recognition enough to defeat an interference claim?
And Ms. Lyman, how are you so sure that it was Miss Anderson there?
The guy, he was there before by himself taking pictures inside of the basement. And then
He was what?
there before taking pictures inside of the basement. And then this time,
What do you mean so I recall the issue regarding the basement. You're saying this guy entered the home.
no, he didn't come in. That's who was taking pictures outside in the window. Like through the basement window.
That you had talked about before.
And then I seen her, that's why the hand was up when the car had came back past.
So your testimony is you saw Miss Anderson in the vehicle.
Yes.
On what would have been the third video that the court received.
It was the guy coming back around from the back of the house after he seen the camera.
Well, no, I think I may have received them in a different order. But the last one I had was actually, it looked like the back of the premises and there was a deck.
Yeah.
The camera, the deck I'm seeing, is that the deck that's attached to the premises you rent?
Yes.
Okay. And Miss Anderson, you're indicating that you know nothing about that individual. Miss Lyman, you're sure that that's the individual that was taking pictures inside the premises?
Yes.
I never.
They never came inside. They were just taking a picture from outside in the basement.
Right, right. What were you going to say, Miss Anderson? I want to give everybody an opportunity to say what they're going to say.
I never sent anybody to take pictures of the basement. You said you let somebody in to take pictures of the basement. I never sent
No, she
anybody.
did. She didn't let someone in. He stood outside and took pictures.
I didn't send it.
Anything else additional from either side before the court rules?
Not from plaintiff.
Anything else, Ms. Lyman, you want to tell the court?
This is the quiet before the ruling. Judge Simpson offers a final chance to add facts, not arguments, not emotions. This signals that the evidentiary phase is closing. From here on, the judge synthesizes everything: rent math, escrow rules, security deposit violations, and interference claims. The foundation has been laid carefully. This moment reminds viewers that good courtroom advocacy isn't about talking more. It's about saying what matters before the door closes. At this point, who do you believe Judge Simpson is leaning toward, and why?
No, I'm just trying to make sure that the only thing that I have left to pay is the last 3 months, which is the $9,900. Correct.
Well, okay. I'm gonna do it this way. Anything else you want to say? And I'll let you know what you have to pay.
No, not really. I just don't think I should be responsible for court costs, just because when we started coming, the rent was already paid. And yeah, about the water bill, I don't really feel like I should be responsible. Just she took it out my name, paid it herself, but if I have to, I will just the company.
What I'm going to do is I'm going to render my decision, and I'm going to do it this way. The original case that was filed, which is, and let me just get it. It's 25-1C-2176. And that's the one that I'm going to render the decision on. Two, 176. All right. And the court has throughout this entire thing, first of all, reviewed all of the documents presented by the parties in detail. And frankly, am unsure, except as to really what is animosity between these parties as to why there is so much stuff here. And from the perspective of the plaintiff, I would just indicate that many of the allegations made by the plaintiff regarding her need to get into the premises, certain things that need to be looked at, and all of those things, quite honestly, the court views as just some pretext to interfere with the possession by Ms. Lyman.
This is a critical judicial finding. By calling the landlord's actions pretext, Judge Simpson is saying the stated reasons, inspections, concerns, utilities don't hold up. Instead, they appear to be excuses masking an intent to interfere with the tenant's lawful possession. Courts take this seriously because possession is the heart of a lease. Once a tenant has it, a landlord cannot undermine it through pressure tactics. The judge connects dots across hearings, highlighting repeated attempts to gain access or exert control without evidence of damage or lease violations. This finding reframes the case. It's no longer just about unpaid rent. It's about misuse of authority. And once that line is crossed, remedies expand beyond money owed. Engagement question. Should courts be more aggressive in labeling conduct as harassment when power imbalances exist, or does that risk overreach?
There wasn't a need. We went through, and just by way of example, we went through a whole series of hearings regarding the looking at something in the basement of something that potentially could occur that she wanted to get in the house. But Ms. Anderson was really letting her true motivations be known, because every time she would indicate that she needs to look in to make sure that the premises are in some way damaged. And there was no indication whatsoever that Ms. Lyman had done that. She was then at another previous point accusing Ms. Lyman of not being the actual tenant, going so much to the extreme of asking the court to tell her to turn on the camera because that wasn't the person that she rented from and that she was dealing with somebody else. Every hearing, the person that's been appearing has been Ms. Lyman, this Ms. Lyman that I see here today. No one else has appeared. It also seems a bit disingenuous for the plaintiff to say that, because there would have been in-person contact prior to the rental in which she rented to Ms. Lyman, and the like. Ms. Lyman may have had people there. She may have had other things, but Ms. Lyman has been the one here and been the one taking responsibility for that. So I don't think that Ms. Anderson, frankly, I'll just be blunt about it. I think she wants to have control of everything, including Ms. Lyman, what Ms. Lyman's doing, who Ms. Lyman has there, and the like. And none of it makes much sense to me, if she wanted to inspect for damages mid-lease, then inspect for damages mid-lease. But she came in here accusing Ms. Lyman of fraud. That has not been substantiated in any way whatsoever.
Judge Simpson flatly rejects allegations that the tenant committed fraud or wasn't the real occupant. That matters because fraud claims are serious and dangerous when unsupported. Making them without proof can backfire badly, as it did here. The judge notes the consistency of the tenant's appearance and responsibility throughout proceedings. That consistency contrasts sharply with the landlord's shifting explanations and incomplete records. Courts value reliability over volume. This moment further erodes the plaintiff's credibility. Accusations that aren't backed by evidence don't just fail, they harm the accuser's standing in the rest of the case. Viewer question: when unsupported accusations are made in court, should there be consequences beyond losing credibility?
That Ms. Lyman was somehow fraudulently renting the premises. It was just said that that was it, and that it wasn't Ms. Lyman. And, you know, and just over and over doing that. And I don't know why Miss Anderson wanted to do what she was doing, but it just throughout the course of these proceedings and hearing after hearing, just this sort of berating of the tenant, saying that she wasn't doing something, just continued. While I've heard what Ms. Lyman has said and said through counsel about not knowing that person in that vehicle, I am having a very difficult time believing that to be the case, because there were people coming, as testified by Ms. Lyman before, that there were people coming to the premises, all coinciding with Ms. Anderson wanting to get in. Frankly, if this were just a simple issue, and it should be, and that's how the court's going to view this case, it's a simple issue. This is a non-payment case. That's all that it is.
Judge Simpson intentionally simplifies the lens. Despite the noise, the legal core remains non-payment. That's not a favor to either side. It's discipline. Courts must decide what legally matters, not what feels unfair or frustrating. But simplification cuts both ways. While it confirms rent is owed, it also strips away inflated claims, improper fees, and conduct-based justifications that don't belong in a money judgment. This reframing prepares the ground for precise math and selective enforcement, awarding what's owed while correcting misconduct. Audience engagement. Is it better when courts narrow cases aggressively, or should they address every grievance raised?
There has been no proof whatsoever presented to the court that Ms. Lyman has damaged the premises, is causing any waste or destruction of those premises, or is in any way abusing the premises or violating any terms and conditions of release. But what I do think is that she's been harassed by Ms. Anderson. And while it may not seem much, when the water bill was coming out, and that kind of popped into this case at some point, she was even in court berating the defendant about paying the water bill. Now, certainly the water bill should be paid, and there are just different ways that landlords go about doing that. But she just continued to go after Ms. Anderson about paying the water bill. Kept saying the water bill was somewhere around $1,800. The only bill that I've received today is for $1,315.83. She claims that there are these other payments. I don't know that to be the case. But that's all I have in terms of the water bill is the $1,315.83. I then have, in terms of rent not paid, and I think it was explained to Ms. Lyman that the rental period starting on the 5th, but her lease doesn't end till the 4th day of the end of the term, is that 30-day or month period. So it's not like she's being shorted. She's not entitled to any type of credit for that. But as it regards the rent on the premises, there's a total amount of $19,800 owing in rent. So when I take that and the water bill together, which the water was supposed to be paid by Miss Lyman, I come up with a total amount of $21,115 that is owed by Miss Lyman. Now, I've not made any deductions for what's been paid in at this point. That would be the aggregate amount due. I am concerned that there are then these additional late fees added on. And late fees should not have been charged for the defendant. Whether she paid it to the court late, there are remedies for a landlord. And let me just put it this way. That's part of the problem, is that Miss Anderson tries to make her own rules. And she was paying escrow to the court and should not have then been charged late fees. Miss Anderson's justification, as she blurted out, as she typically does, was that she paid the rent late to the court, so therefore she's entitled to a late fee. Not the way it worked.
This is a decisive correction. Judge Simpson rules that late fees tied to escrow payments are improper. The landlord's belief that escrow lateness justified fees is explicitly rejected. The judge explains the proper remedy: an immediate trial, not monetary penalties. This distinction is crucial and often misunderstood. Escrow is a court process. Landlords don't get to layer private penalties on top of it. As a result, claimed late fees are reduced significantly. This not only lowers the judgment, it reinforces a broader rule. Landlords must follow statutory remedies, not invent their own. Viewer question: should judges impose sanctions when landlords repeatedly misuse late fees, or is correction enough?
The landlord has certain remedies if she were late paid to the court, which, quite frankly, Sanderson has been able to take advantage of with the whole start of the trial in this proceeding by an immediate trial. But it doesn't give you a right to a money judgment, but gives you a right to an immediate trial. There are those things, but the late fee, not going to do it. So claiming some $900 in late fees, I'm going to take off, because that's what's been paid into escrow. So $300 comes off of that. So of late fees, there is only $600 for late fees instead of the $9 that's claimed. Now, the other problem that I have is that I don't know where Ms. Lyman's security deposit is. I can't get a straight answer. What I know is it apparently is commingled with the funds of the plaintiff. It's absolutely inappropriate under our statutes and should be held in a separate account, for which Ms. Lyman, because it was really her money that the landlord is holding, has to be notified as to where it is, the financial institution and the like. That is a clear violation of the law.
This is one of the strongest findings in the decision. Judge Simpson confirms the security deposit was commingled and that the tenant was not properly notified, both statutory violations. Importantly, the judge separates this from rent owed. He doesn't excuse non-payment, but he does weigh the violation heavily when assessing fairness and offsets. Courts treat deposit laws as consumer protections, not technicalities. This finding explains why the court is willing to credit the tenant for interference later. The landlord's failure to follow basic compliance rules undermines her position across the board. Audience engagement: should deposit violations carry automatic penalties, or should courts retain discretion?
In the way that Ms. Anderson is conducting her business. I also don't know that her counting is all correct. Because there were certain numbers that had to come off and come on, and somehow the notice that was sent on this case would have been incorrect. The notice that was sent to the tenant regarding the amount she owed would have been incorrect because there was at least the $100 credit, and then presumably other credits that went to the tenant. Credits of, and I say it this way because it's money that she's paid. It doesn't necessarily change the bottom line, but it's certainly money that she's paid. And Miss Anderson knew or should know that she's received the funds from Miss Lyman. But somehow or another, Miss Lyman has to get herself here to explain to the court that I made these payments. There isn't a ledger in the sense of a ledger of her payments each month, because apparently Miss Anderson believes she didn't have to keep a ledger, an account ledger, until the time that she filed the notice, or until, actually what she said is until she paid into escrow. I don't even know where that comes from. That doesn't even make any sense. And certainly it's not a sound business practice by any stretch of the imagination. So what I have is, I have, with late fees, rent, and water, I have the tenant owing $21,715. She has posted, and counsel, remind me, what were your costs that you were claiming?
Costs are $183.59.
Okay. And while Miss Lyman doesn't believe that she didn't have the cost because rent was paid, I don't find that necessarily to be the case. I think the original case could have been filed. But it just wasn't. I mean, it could have been filed. It was filed. I'm not even clear when I look at everything that it needed to be filed. As it seems to me that for the most part, Ms. Lyman finds a way to get herself ultimately paid in full. And I'm going to say this way. I think Miss Anderson was trying to harass Miss Lyman.
The judge goes further, calling out the filing of a second case as pressure. This is rare and serious. Courts frown on duplicative filings designed to intimidate or accelerate payment outside proper channels. Judge Simpson couldn't get a straight answer as to why the second case existed. That ambiguity, combined with earlier conduct, supports a finding of intentional interference. This moment explains why damages are coming. It's not about punishing mistakes. It's about deterring misuse of the court system. Engagement question. Should courts penalize strategic filings meant to pressure tenants?
I've said it in the regard to how she handled her tenancy. But I also think, and this was not certainly counsel's doing, but there's a case that was pending before the court that the court was coming back to render a decision on. And for some inexplicable reason, Ms. Anderson files a new case that then gets served on Ms. Lyman as, frankly, as the court interprets it, is just an added attempt to try to pressure Ms. Lyman to pay. The court never got a straight answer as to why this was even filed. But I just find it odd because also and falsely, frankly, at least based upon what's been claimed here, in that complaint, she alleged $1,500 water bill, which supposedly was due October 6th. Now, I've never seen a rounded off water bill. I'm sure it exists someplace, but I've never seen one like that. And that's what she put on there. And again, I think it was just an attempt to try to pressure Ms. Lyman into doing something that maybe she was entitled to. But again, I could never get a straight answer as to why this next case was even filed. It made no sense to me whatsoever. This action was already pending. And again, it just made no sense whatsoever from the court standpoint that it was filed. Because of all of the harassment, I think intentional interference with Miss Lyman's quiet and peaceful enjoyment of the premises, what the court is going to do is the court is going to award on her counterclaim on that $1,700 to her.
Here's the consequence. The court awards $1,700 on the counterclaim for interference, an amount Judge Simpson notes is historically large for this court. That statement alone underscores how seriously the conduct was viewed. This award directly reduces the landlord's recovery. It's a tangible acknowledgement that the tenant's experience mattered and that rights were violated. From a retention standpoint, this is the payoff. All the earlier threads, water bills, name changes, videos, commingling, culminate here. Viewer question: does this award feel proportionate to you, or should it have been higher?
That would bring the plaintiff's judgment to a total amount of $20,015 plus the $183.59. And counsel, I just want to make sure, which case are you getting your cost from? Because is that the new filing or the old filing fee?
We became involved in this case. I mean, in his proceedings after the second case was filed.
Correct. So that I just want to make sure those are the costs you're giving me is from the second.
Well, no, actually, her figure as the cost come from the first case. Is that right?
I was combining.
She was combining them.
Pardon?
She was combining the two cases.
It was the first case. I don't know.
Oh, you don't know. Well, we'll just take the filing fee and the service fee and filing fee was what, $7,575?
No, well, here's the problem. On the first case, I have a filing fee of $130 and a $55 filing fee on the second case.
Okay.
I have a service fee on the first case of $32.30, as well as $32.30 and $32.20, respectively, between the cases.
32.30, 32.30 and 32.20.
So, yeah, so here's what I'm gonna do. The only cost I'm gonna award, counsel, is I'm just going to award the lower of them. And so I'm just going to award $87.20 in cost.
Okay.
Because and again, it's on a case that should have never been filed, but that's the way I'm gonna do that. And that would make the total judgment to the plaintiff. If they have me do math here, but 0, 1. I get $20,102.20 is the total judgment amount. And this I am $20,120.
Okay, $20.
Or 20102.20.
All right, okay.
And then Ms. Lyman has posted into escrow, subtract off of this $8,870.
May I ask, has the court determined that that is the correct figure? Because it was 66 when I came in this morning.
There were 66, and then there was another. I had determined that there was
Okay.
2,000. Yeah, posted.
Okay.
Ms. Lyman, you have your hand raised.
Yeah, because that doesn't seem right to me. If I only owe, the last 3 months, that's 9,900. With the water bill, that should only be $11,000. And then
11,000. Correct. You know what? I know part of what. So here's what I did. I'm only going to. So the total figure that I came through with rent, water, and late, let me just run through it's $21,015. Okay. I'm awarding them cost of, let's say,
8720.
87.20. Would then bring the total amount of their judgment amount up to $21,802.20.
so even in the prior proceeding, when she said she wasn't counting,
I only gave late fees for 4 of those months.
even though that she had said before.
I understand what she said, but under the lease, she's entitled to.
Even if she said it, or even if it's a recording that she said it.
So how many times do you think you're going to answer the question and get a different answer from me? Well, I think I'm pretty clear in what I said. And then I'm going to subtract out from that figure the $8,870.
Which gives you 12,920,
12,920.
32.
All right. So after the escrow is released to the plaintiff, that would lead to a judgment of $12,932.20.
Judge Simpson walks through the final math carefully. Rent, water, adjusted fees, costs, offsets, escrow credits. The final judgment lands far below the original $22,000+ claim. This demonstrates judicial precision. The court enforces obligations without rewarding overreach. It's a balanced outcome. Money owed is recognized, but misconduct is not ignored. The judge also sets a clear deadline tied to eviction, reinforcing that compliance now matters more than argument. Audience engagement. Does this outcome feel balanced, or does one side still walk away advantaged?
Even though half of those months I've been harassed.
You need to listen to everything I said. I gave you a credit of the total amount of $1,700. That is for the harassment that you received. Really what is interference with your possessory interest to the extent it was interfered with. I gave a $1,700, which I will tell you historically is a large amount for that type of claim from this court. But I think that.
Does that need to come over that?
No, I already took it out here. Okay. So I gave you credit against that amount because this number would be a lot higher otherwise. Right. It is nowhere near the figure that we started out with of the 22, almost 22 and a half that would have been owed, which would have then gotten us somewhere in some bizarre like neighborhood. All right. But basically, if you look at it, Ms. Lyman, effectively, it's going to be the cost, the water bill, and the 3 months of rent plus what's owed on September rent. That's going to comprise that amount.
All right, we will prepare.
All right. So it's the total amount is $12,932.20. Ma'am, I know that you were looking at getting everything paid by the end of the month. How long is it going to take you to come up with that? But you were looking at the 90,
I was looking at the
99, basically 10.
Okay, so I have to pay the water bill in whole instead of paying it in small increments like I was gonna do with the water company?
Yes. That was also part of the calculation that went in with the 17.
Right, but I'm saying,
Because I think she interfered with your ability to have a payment plan for the water.
so I can't do the water bill in a payment.
Excuse me?
No, I'm saying I can't do the water bill in a payment plan.
She paid the water bill. You're supposed to pay that water bill as it becomes due. I understand what you were trying to do. Again, in the 1,700 that went into my calculation because and I'm not going to even ask because I don't get a straight answer as to why she did that, took it out of your name and the like. But I've taken all of that into account. And so now I'm asking you, and because I also understand that if the water bill were out of the mix, you would basically have around a little over 10,000 that would be due. So let me ask you this. Because you got about 13,000 that you got to pay. How are you going to get that paid? Because you're going to be coming up on January rent also, but this isn't included in this. Let me just ask you this. How much time are you going to need to get this paid?
A little after June.
Pardon?
A little after June.
Like, what does that mean?
Last week of January, February.
I can't give you that long because you're going to have January rent up again. You follow me? I mean, you're going to have that next 3,300 click again, which is going to kick this figure out. And Ms. Lyman, so that you also understand sort of the time frame that I'm working on. So you got that coming up, but also today's what, the 9th. So the normal rent date in this case would be the 19th to pay it. But I heard what you said to me about when you were going to get the rest of that paid up. Here's what I'm going to do. All right. Listening to what you said, the order of eviction date on this matter will be January 5th, 2026. So that amount would need to be paid by that date. Now, so that, and I'm going to say this directly to you, Ms. Anderson, the monies that come in must be applied to the judgment. So if she paid $3,300 and the judgment is still outstanding, applied to the judgment. You can't just say I've taken it as January and she still owes me this. It may be that if she gets that money all by that amount paid and it hasn't paid January rent at that moment, you're going to have to start over on another case. Am I clear on that? Am I clear on it? This is just simple math. Any monies that come in must be applied to the judgment. Don't come back in here having accepted 3,300 saying you're applying it elsewhere.
We understand that, Your Honor.
Thank you. I'll let your attorney explain that to you.
There's one point at the conclusion of this case. What is it that?
The 2 pen drives.
Yeah, she said the court has 2 pin drives that she'd like back.
you know what? She's been bugging me about those things, specifically direct to the court of motion of what she would like returned. And I will look at it, but nothing is going to be returned until the appeal period expires.
I have one other question. Do we prepare the judgment or does the court prepare the judgment?
I'll let you do it. All right, thank you. I'll talk to you. Thank you. And Ms. Lyman, make sure you get a copy. At some point, they'll prepare the judgment. I'll sign off on it. Make sure you have a copy of it. Come up to the court, get a copy of it. All right, thank you.
Oh, yeah, no, it's just.
So, is everybody here on the explanation?
Yes, sir.
Okay, everybody's here?
Mhm.
Okay, you guys have to give me a couple minutes. Otherwise, I'd find somebody to yell at. It'd probably be him, right? All right, Kurt's gonna stand in for you. No, I'd take her too. Kurt's gonna stand in for you.
All right.
This case ends where it should, with clarity. Judge Simpson sets a firm deadline, applies payments correctly, and issues explicit instructions to prevent further gamesmanship. The message is unmistakable. Follow the judgment, apply funds properly, and don't come back with recycled disputes. In summary, the court found substantial rent owed, but also found harassment, improper late fees, and a clear security deposit violation. The landlord's recovery was reduced, the tenant's counterclaim was validated, and the court restored balance to a case that had spiraled unnecessarily. The broader implication is powerful. Landlords must respect statutory boundaries, keep accurate records, and avoid using utilities or filings as leverage. Tenants, meanwhile, must understand that escrow protects, but does not erase, monthly obligations. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns.